Okay, welcome to the case update, CLE. Today we're going to go over the 2021 Court of Criminal Appeals update. I'm Seth Fuller from Patel Fuller PLLC. Next to me is Jason Niehaus from
Bodkin, Niehaus, Dorsey, and Jolly PLLC.
That's it. And websites in the link below. So today we're going to go over all of the 2021 Court of Criminal Appeals cases, updated to what, October?
Yes, updated to September 15th.
September 15th, all right. So let's just start this out. Let's go.
Yes, sir.
No, that's you.
That's me. I'm not. I don't matter.
And we will be providing a link to the slideshow so that will have hyperlinks and everything. Is that correct?
The PowerPoint is not hyperlinked. The paper is hyperlinked.
Okay, well, I'll provide a link to the paper, which will be hyperlinked, and get that out to you, so you can just look in the description below for the link. All right, so now we have unresolved issues from 2019. Is that correct?
Yes. Yeah. As everybody knows, the coronavirus shutdown has kind of killed off the ability for us to litigate some of the fun issues that came out of the 86th legislative session that ended in 2019. Amongst those are the DWI Superfine, which was Transportation Code Chapter 709, and whether that's constitutional. Whether it's constitutional as a possible violation of the separation of powers provision, is using the judiciary as a tax collector. Second, whether it's outside the range of punishment, if it's a fine as opposed to a court cost. And then we've got all of the fun hemp/marijuana/cannabis issues, where the legislature decided that cannabis is no longer necessarily, but probably still is, marijuana.
So what you're saying is they still haven't touched on these things. These
Correct.
are stuff we won't have a solution to. Obviously, whether the DWI Superfine is constitutional, and whether these crazy hemp marijuana things are constitutional. Obviously, these both are criminal issues that are very important. What I've seen so far, I don't know about you, is the DWI Superfine in all the courts that I have seen has been very sparingly applied.
Yes, is the indigency exception in subsection C of the Superfine has proven to be helpful for especially the indigent clients that wouldn't be able to pay in the first instance.
And it's not usually applied for, or at least in the courts I've seen, for deferreds, correct?
Correct.
And so you're just talking about convictions, and then if they're indigent, they don't pay the superfine.
Correct.
If you got a rich client who's getting convicted, maybe they'll have to pay the superfine. So maybe that's why it hasn't come up so much, right?
That's part of what I expect. Yes, is the now that Uber and Lyft have proliferated, the number of more well-off clients that are being arrested for DWI has declined precipitously, and I think that's part of the reason we haven't seen much in the way of enforcement on the superfine.
And so then we have the hemp stuff, and that's just basically a bunch of us crafty criminal lawyers trying to figure out how we can get away with the semi-legalization of hemp, what constitutes probable cause as far as smells. There was a smoking exception. They took it out, either taking it out or the courts have found. Anyways, but those we haven't reached yet. And then we also have the non-Delta 9 THC, specifically Delta 8 THC and Delta 10 THC.
Yes.
I haven't tried that. I did try the Delta 8. It's completely legal, and it's marijuana. Like, I'm just telling you, guys.
Yes.
It's marijuana.
And like we touched on in the legislative update CLE, the legislature had been poised to fix that, and then opted against actually voting on the creation of what would have been penalty group 2B, which would have equalized treatment for concentrate and leaf marijuana,
so that the dabs, the oil, the vape pens. That's what we're talking about.
Yes,
this is essentially the vape.
The vape pens and the joints would have been treated the same way. and then it would have criminalized all of the non-Delta 9 isomers of THC, including the Delta 8.
To that same level.
Yes.
So the Delta 8 would leave your local coffee shops and pretty much everything, and then we'd have a whole nother question about, how they can do that with all the Delta. But anyways, we haven't reached that yet. So now we're on to the ones we have reached. Writs and death cases,
yes.
Right?
Yes. First up are the writs, the writs where relief has been granted, and the death penalty cases from 2021. Number one is Cook, is a DWI with child case. This goes to the unit of prosecution for DWI with child. And what this comes down to is how many times you can be convicted for DWI with child if you have multiple children under the age of 15 in the car when you get stopped for DWI.
So they were, and I haven't run across this, but it sounds like some places were stacking up for each child in the car?
Yes.
Oh, okay. That would make sense for kind of an endangering, but it did, obviously this was an issue. So, but they granted that. They said
they did. Yes, they granted relief there. That was a double jeopardy violation because the unit of prosecution is the driving while intoxicated, not the presence of the child.
Pretty much common sense.
You would think so, yes.
Who did this?
That was an opinion by presiding Judge Keller, who's usually not terribly defendant friendly.
Oh no, I'm saying what court? Do you know which court it was at?
I don't recall.
Okay, yeah, whatever. They went hard. That's crazy.
Yes.
Okay.
Next up is Stephen Thomas. Thomas here abrogates Moon. So those of you that do juvenile work,
That's
Moon.
big.
That's real big. Moon was a case that was resulting in too many acquittals, so we couldn't have that be the law anymore.
No. So Moon was one of those that in the juvenile courts we were like, whoa, how did this happen? This is awesome. Like, this is crazy. And then they've fixed it now. But essentially, it was kind of a niche part of the law where they had to specifically enumerate certain findings in order to send someone to TJJD.
Yes.
And if they didn't enumerate those findings, then you couldn't send them to TJJD, and that was retroactive.
Yes.
And so essentially, a bunch. Now the courts corrected it almost immediately. They just made sure they made those findings. But the ones that didn't were all getting acquitted. So now the Supreme Court said, "Whoa, you can't. Never mind. Sorry, we didn't mean to create this," and they changed it. Correct?
Yes, and this is essentially what happens when the defense bar gets a little too overzealous with how retroactive something is. This was one where the habeas applicant, because this goes up on a habeas writ. Multiple decades after being convicted, argued that, hey, Moon, which didn't exist at the time, should have applied to my case, and the Court of Criminal Appeals kind of seized on this opportunity to go, not only does it not apply to you,
Moon's gone.
Yep.
We're not just going to go, thanks a lot. Do we know who did that? All right, never mind. Thanks a lot, defense lawyers. How dare you?
I mean, hey, you've got to zealously advocate for the client you've got.
And there
unfortunately,
you go.
sometimes it means making bad law for everybody else.
That's unfortunate.
I mean, that's functionally what we had with Oliva back in 2018, where the public defender's office out of Houston was arguing that DWI seconds were elemental to the Class A. DWI prior is elemental to the Class A DWI second,
which got us having that as an element, and therefore they could bring it up at court.
That was the goal, yes, but that was one where the CCA took it up, and I was amicus counsel on that case and convinced the CCA to reject the agreed position of the parties, because the state prosecuting attorney's office took it what had been the minority opinion out of the 14th District Court of Appeals, which covers Houston and surrounding areas. It was like, hell yes, we want this to be the law everywhere. Never mind that it's just the law in one of our 14 appellate districts.
No, they were like, yeah, let's go. We can bring up priors. Let's do it.
This will make it easier for us to convict everybody. Let's run with this. So that was the case where the National College of DUI Defense Attorneys and Dallas and Denton defense bars brought me on as amicus counsel to
And
argue.
it was just for literally an individual case, right? I mean,
Yes.
it was like for that particular case, they wanted to say that they didn't meet the elements or something to that degree.
Yes, and
right?
that's great lawyering for that one client, even if it's gonna fuck every other one.
Yeah, he was like, yes, go,
but CCA
go
rejected.
public defenders.
Yeah, but CCA ended up rejecting the agreed position of the parties in favor of my position, which was that the second is the DWI first is not an element of the second; it's a punishment enhancement. Next up, Mr. Casey.
Mr. Derek Casey.
Derek Casey was convicted on a failure to ID and received a... No, I take that back. Mr. Casey was not a failure to ID. Mr. Casey was an assault public servant, was sentenced to 25 years imprisonment. This one was reversed for a Brady violation because there was no evidence that the officers identified themselves prior to the assault occurring, which is an essential element of an assault public servant.
And did they not reveal that? The DA, I mean, the prosecutor failed to disclose that they didn't do that?
Correct. Yes, this was something that was caught on post-conviction relief quite a ways after the original conviction, where the appeal had actually been dismissed. It was a voluntary dismissal under Rule 42 in lieu of an Andrus brief. And it wasn't until somebody actually went back and started digging through the discovery that was provided under the Morton Act that they realized that, hey, there's no evidence of identification here.
And so doesn't this have to do with, it also kind of shores up Brady in what the prosecutor has to know, is that correct?
It does to an extent, yes. This one gets flipped as an involuntary plea, is the argument that was made here. And there's a growing subdivision of the Court of Criminal Appeals that is of the position that if you plead knowing there's things you don't know, you don't ever get to come back and say, hey, I didn't know this and I wouldn't have pled if I'd known this.
Okay.
So that is something to watch.
So wait, you're saying that is the case, that if you plead knowing that there's something you don't know, that's still the case, that you were waiving essentially your Brady?
At this point you can still raise it, but there's a growing faction of the Court of Criminal Appeals that is looking to permanently eliminate involuntary plea claims based off of ignorance of facts that at the time of the plea.
That you could have known.
Correct.
Essentially. Okay. Next up, State Texas, El Rey John H. Best.
Yes, this is a mandamus proceeding. This is a multi-defendant capital murder case out of Houston where there's very limited evidence available for forensic DNA testing, and the defense lawyer essentially says, hey, Houston Crime Lab's got a history of being a fuck-up. I either want to observe the testing, or I want the testing recorded, or I want to be able to determine what lab does the testing. And the trial court essentially was like, yeah, that's reasonable. And Kim Ogg did not like that.
But she got her way, right?
So they took it up on mandamus and said, Judge, you don't have the authority to compel DPS to do, to create evidence by requiring video recording, and you don't have the authority to make them let the defense attorney watch the testing. And the Court of Criminal Appeals essentially said, yeah, that's right. You have a lot of discretion for a lot of things, but you can't compel the creation of possible defense side evidence.
So all the defense attorney was trying to do was make sure, get some sort of assurance of the validity of the testing, essentially record the testing so that he can then give it to an expert of his own, so that the expert can then say, no, they didn't do it right, or yes, they followed the procedures. Yes. Correct?
And that's particularly important in this case because there was not going to be enough evidence left for subsequent retesting. And
so they said, the CCA says, you don't have to do that because that's creating evidence, because requiring them to videotape is creating more evidence.
Yes.
That's an interesting one. All right, so, but pretty specific. I don't see this applying to a lot, but it would apply to a lot of murder cases, or rape and murder cases.
Yes,
right?
This is one of those ones where it kind of limits the trial court's discretion to be able to say, state, go and make this evidence. So your most common application is going to be like State Ex Rel Monk, which was the creation of the NCIC, TCIC background checks. They came out of the Eastland Court of Appeals 6-7 years ago.
All right, so just watch for this. If it's but there's nothing stopping the labs from doing this. Correct. It's just the court can't make them do it.
Correct.
So you still have an argument after the fact that it wasn't done correctly, that they did have screw ups, but you just can't ensure that they're not screwing up.
Correct.
You can't make the court can't make them ensure that they're not screwing up.
Correct.
All right, interesting. Stephen Vernon.
This was a due process violation, state's breach of plea bargain. This is a non-published opinion, so it's not precedential, but the underlying facts on this one is the habeas applicant agreed to forfeit his Corvette and plead guilty in exchange for the state not contesting his parole eligibility. Well, the state then proceeded to take the car, send him to prison, and then repeatedly contest his parole eligibility. So he filed a writ and said they breached their plea bargain agreement, and the CCA says, we agree, please vacate it.
Do you remember how long he was on? Because to get to parole, he had to be there for a while, right?
He had to be there for a while. He was, I believe, a 20 or 25-year sentence.
So he was in there for a while.
Yes.
Through several paroles. But they said that he has to have, what, a new trial?
Yes, they vacated the plea and sent it back to the trial court.
There you go. And so, again, this is just prosecutorial misconduct. There's no doubt, right?
Yes.
I mean, you can't make an agreement that you don't abide by. And that's the one thing the court's seeming to still stick to is if the state, they're still making the state do what they agree to do in a lot of places. So that's good. All right. Stephen Barbee. This is another writ case on relief that's available under McCoy v. Louisiana, which is the 2018 U.S. Supreme Court case that says that defense counsel cannot supersede the client's decision to plead guilty or not guilty. Okay, so this goes towards what us criminal defense attorneys can decide and what our clients can decide.
Yes, and this is the case that decides on whether McCoy can be raised in a subsequent writ or whether that's barred under 1107 subsection 4.
Okay, so now outline what we can decide. The client can decide whether to plead guilty or not guilty.
Correct.
Whether to take the deal.
Correct.
And that's it, right? What else we got?
Whether to testify during guilt.
Oh, yeah, testify. They can decide that.
And whether to testify during punishment.
That's right. Okay, and so those are
and
the
whether
things
and whether judge or jury assesses punishment.
Okay, and so those are the 5 things that they can decide, and what does this do to those 5 things?
This doesn't really move the needle any. This says that relief under McCoy is not retroactive in a manner that can be raised in a subsequent writ.
Okay.
Because the legal basis was previously available under a case called Florida v. Nixon, which was a 2004 Supreme Court case. And the only difference between Nixon and McCoy is factual distinctions, not legal theories. So
this is one of those crazy ones where the defense attorney pled guilty over his objections?
That was McCoy, yes.
Yeah, and so this one says that that can't be raised now by everybody. Is that correct?
This is one, yes. What this does is this limits the retroactive application of McCoy to areas where there is a disagreement between counsel and the client on whether it's advisable to kind of throw client under the bus and beg for mercy.
Okay.
The most recent update is just about a week ago. Mr. Barbee's writ and request for stay of execution was denied, so he will, by the time y'all see this, probably have been executed.
And just to be clear, McCoy was for the punishment purposes. Is that correct?
Yes.
So he had pled guilty, but then the defense attorney kind of was let's ask for mercy, and the client said no, I want to go with he was found guilty.
He was
correct?
found guilty, yes.
And he wanted to go with the I'm still innocent. And so the defense attorney said that's a terrible idea, which it almost certainly was.
Oh, yes. There were 911 calls and other evidence that pretty clearly indicated that McCoy was going to be found guilty.
And so then McCoy said, no, you can't do that. You can't override whether they say they're guilty or not. So now this says that, well, okay, but we're not going to go back through all the cases where that did happen and rehear those. So this is just basically limiting their caseload to the ones that have that the here on forward.
Correct.
Okay, and and this guy's obviously probably, like you said, going to get executed before it's brought up again. Raleigh Warfield.
Yeah, Raleigh Warfield. This is a
non-published opinion.
Yes, this is an interesting one. This came out of Dallas, where the DA's office caught a discrepancy between the charge and the evidence on an internal audit. And what had happened here was he had pled guilty to fraudulent use and possession of more than 10 less than 50 items of identifying information. The state realized that they only had 8 or 9 items of identifying information, and the state's conviction integrity unit notified counsel and said, hey, he pled to something we can't prove.
This is after he pled?
Correct.
Okay.
And this is the case where the growing majority of the CCA that wants to undo involuntary plea arguments writes their kind of underlying legal theory.
Okay.
This is one where the dissent functionally says, had you had a trial, you would have learned these things. You elected not to have a trial, and you can't complain about the things you could have found out but didn't.
Okay, but what did the majority decide?
Majority opinion granted relief on the involuntary plea argument, remanded for resentencing.
Okay, so this is, at least we have a limit, which is if you plead to a set of things that you actually didn't do, you can have some relief.
Yes.
And so, is this a new trial?
No, this is a new punishment proceeding.
New punishment. Okay. So they punished him for the over 10, and so he's going to be still found guilty, but it's going to be limited to the punishment of the under 10?
Yes, and I believe he's already served out the maximum on
He's done. All right. Okay. But you're saying that the dissent is important to read.
Yes, the dissent. Yes, the dissent here is essentially wanting to make actual innocence claims unavailable after a plea bargain.
And so watch out for that sort of thinking to come up in all the future involuntary plea cases.
Yes.
Kim Ogg. We just talked about her.
Yeah,
her ears must have been burning.
Yeah, this is a COVID case. During the COVID shutdown, jury trials were unavailable. Defendant wanted a speedy trial. State refused to waive jury trial. Trial court said, too bad, so sad, you're getting a bench trial. State took it up on mandamus. Again, Kim Ogg's office out of Harris County. And the CCA said, nope, state gets a right to a jury trial. Even where we can't have them, he gets to keep sitting in jail.
That's so interesting. So this is literally, just to be clear, a DA's office saying that you can't have a trial in front of the judge because of COVID. So they're just basically just keeping him in jail until a jury trial. That, by the way, how often does the DA pick a jury trial over a bench trial? But in this case, they did probably, I mean, I'm not going to, impeach anybody's morality or credibility, but probably just to keep the guy in jail longer. So the court says that's okay because it was COVID, right? I mean, that's the essential thing, right?
Yes.
And so, and we don't have any. The speedy trial stuff is essentially stayed for COVID, if this sort of thing happens, right?
That is going to be an interesting issue that I have not seen come up yet.
It's not seen come up, but this is kind of the precursor. You'd agree with that? Because this is kind of he was trying to get around it, right?
Yeah. Well, in this, this case, if the defense attorney on this case did not file a speedy demand as soon as the state filed this mandamus petition, he's probably committed an act of malpractice.
And again, maybe he's had it because we have had the courts since probably this came up, right?
Yes.
But essentially, this was kind of I would think they would grant this, or I think they would turn it down because it was actually the DA, right? If they were worried about the speedy trial and the jury, right?
Yes.
So in other words, they would have said, yeah, the judge has. I'm guessing the defense attorney's argument was, this is the only way to get a speedy trial.
Yes.
Okay, and so obviously in COVID, probably not concerned about speedy trial stuff.
That's fair. Yes.
Another Harris County one?
Another Harris County case. This is Raymond Riles. This is a fourth habeas writ. It's a Penry violation, which is...
What's a Penry go over a Penry violation?
Yeah, this is a jury charge violation where there's mental health evidence that requires a specific mitigating evidence instruction that was not given in this case. It should have been, because this guy is fucking nuts.
He's crazy. He's crazy, and the jury wasn't allowed to know he was crazy.
The jury was inadequately instructed on his mitigating evidence, his mental health mitigation evidence. So this got raised finally in a fourth writ. He was set to be executed since they granted the writ. That's going to go back for new punishment proceeding. The majority opinion is not anything special. It's the dissenting opinion that is an interesting read.
Why is that?
That's our next slide.
Oh, next slide.
The dissenting opinion by 3 judges on the Court of Criminal Appeals essentially says we should kill him because he's incompetent, and that's easy. The judge there essentially says that given his mental health history, he's going to be held incompetent. If he's incompetent, he might be parole eligible. If he's parole eligible, he might get out. If he gets out, he might be homeless. So fuck it, let's kill him.
What was the dissent? What are you talking about here? How many judges were on that?
3 on that one.
All right.
And that was and the thing that makes that dissent even more fucking infuriating is that it's premised on on Riles' inability to consent to representation by habeas counsel.
Which most people would just go, well, if you can't consent, that's not be held against you.
Because he's incompetent, he can't consent to habeas representation. But because he's incompetent, fuck it, let's just kill him.
Yeah, that's pretty crazy.
And no, from the briefs that I can get access to, the issue of consent was raised by the dissent in the first instance. It was never raised by the DA's office.
So in other words, they took this up on their own.
Yeah, this is a
to go above and beyond to try to kill this guy.
This is a sitting judge on the Court of Criminal Appeals advocating for the state to murder somebody
who's incompetent.
Yes.
To even file this.
Yes.
Do you know who are those judges?
Judge Slaughter was the one that wrote that opinion.
All right. Wait, what? What did you say his name?
Michelle Slaughter.
Oh, her name was?
Yes.
Slaughter?
Yeah. Fitting, right?
Man, you just... It's like the 666 laws thing. You think you just stay away from that. That's all I'm saying.
Yes.
Okay, next we got... that's a pretty crazy one. Terrence Andrus.
Yes, Andrus is one where the defense attorney was found to be ineffective by the Supreme Court of the United States. SCOTUS remands it for... further proceedings after finding defense counsel to have provided ineffective assistance in violation of the Sixth Amendment. And the CCA goes, that's cute, SCOTUS. He was fine. Fuck you guys.
Based on what?
The CCA essentially reweighed the evidence and said that they disagreed that counsel was ineffective and that none of the things that the Supreme Court pointed out as probably affecting the outcome would have affected the outcome. So they left everything in place.
Tell me... How does the SCOTUS let us stand?
I anticipate this one will go back up.
Okay, how does it go back up? Again,
it goes,
I'm not an appeals guy, as much of an appeals guy as you are for sure. Procedurally, what happens here?
Yeah, procedurally, this is a decision by the High Court of the state, so it's subject to a petition for writ of certiorari.
Okay, to the U.S. Supreme Court.
Correct.
Okay, that's what it would be. It would be the U.S. Supreme Court.
Yes.
Okay, and the U.S. Supreme Court, in this case, if they take it up, is going to basically be deciding between SCOTUS and the CCA.
Yes.
Okay, all right.
Yeah, and this would not be the first time that the Supreme Court has taken a case back from the state of Texas after they remanded to Texas and been like, guys, we didn't fucking stutter. This is what we meant.
Okay. Yeah, because the SCOTUS wins. Right? There's no way they say we lose.
Yes.
Okay. Yeah, that's... Well, look, in Texas, we're the Republic of Texas. We're going to have to, say, screw y'all once in a while to the federal government. and do our own thing, even if it doesn't make any sense.
Yes. Petietan, this is a death penalty case. The long and short on this one, this is the longest opinion that came out of the CCA this term, clocking it at over 80 pages. The long and short on this one is you do not get a pretrial determination of intellectual disability for purposes of whether you are subject to execution in a capital murder case. That is a trial question, setting aside how inefficient that system is. That is a trial question. And that is the big, long, short...
What's a trial question? The intellectual disability?
Intellectual disability for purposes of execution.
Is that similar? It's totally different than the incompetence we just talked about, or the same?
Correct. Yes. Now this is not I'm too crazy to be executed. This is I'm too retarded to be executed.
Okay, but that's a trial court
correct
decision on whether they should execute them or not, after having found that they were guilty of the crime.
Yes, and this is after Moore, which isn't the last case that went up and down between Texas and the United States Supreme Court. Moore was heard by the U.S. Supreme Court 2 or 3 times before the CCA was finally like, okay, guys, we get it. Fine. We'll redo our intellectual disability death penalty precedent.
And they redid it, and here we are.
Yes.
Then they're saying that that it's a trial matter, not a pretrial matter.
Yes, because it's a factual determination for the jury.
For punishment.
For eligibility for execution, yes.
Okay. Because I imagine they litigated this as far as competence to stand trial.
Yes.
Okay.
And this is one of those ones where the difference between intellectual disability and competence is the competence is the inability to understand the nature of the proceedings against you or assist counsel. Intellectual disability is just the I'm too dumb for you to kill me.
Okay. And so this is for the guys at the lower end.
Yeah, these are your guys that are going to have a functional and adaptive IQ sub 65.
Yeah, but a high enough IQ to essentially know right and wrong, that they could tell a psychiatrist, yeah, okay, it's bad to kill people. And so why was this so long?
They go through this is a direct appeal death penalty case, so there were a lot of issues that were raised and disposed of. And ultimately, the only one that functionally matters for this one is, they re-raise all of the standard death penalties unconstitutional for reasons 1 through 13, and then they got to the pretrial determination of intellectual disability.
Was that happening? Was there being a pretrial determination?
No, that was the issue that was raised.
Okay, they were saying they should. So they were trying to put in a new pretrial investigation, which is essentially, hey, maybe a jury of lay people shouldn't be deciding how intellectually disabled this person is.
Yes, guys, maybe we should set the question of intellectual disability apart from the question of whether the guy did the heinous thing we want to kill him for.
Come on, man. Jury members, you gotta put trust in your jury members, man.
That makes sense. We can't have that.
Some of those jury members are probably same as him. There's no IQ test for jury.
No, there's not.
So he'll have a jury of his peers. Juan Ramirez.
Juan Ramirez. This is Chapter 64 DNA testing appeal, where client pled guilty and then says, hey, there's this stuff here that might exculpate me. Give me post-conviction DNA testing. And the CCA goes, boss, you pled guilty, so we don't think this is going to change that.
Yeah, so this is the one it's right along with what you've already been talking about and what we kind of expected, which is these, pleas. If you plea, they're trying to give you as little appeals as possible if you plea. So you can't, so put it to test. Here's the thing, even as a defense attorney, I kind of agree with some of this. Now, again, when it comes to the DAs being shady and not giving stuff over, no, we can't have that. But in a case where DNA's been around since like 82, I don't know. We know what's going on here, and so I think if they have all the evidence, if they and the defense attorney have all of that, okay, that's fair. Now it's when they don't get all of that and they're like, yeah, but you knew it could have existed, that I get a little upset and bristly. But this one is actually not too bad, right?
Well, this is one that predates the Michael Morton Act.
Okay.
So whether and to what extent the defense
They
attorney may have had access to the information and the evidence that they're now trying to get tested is speculative.
Okay, all right. So I'll say, okay, then that's a problem. All right. But so they basically say there's no due process right to DNA. So essentially,
you get DNA as the legislature has authorized DNA testing, which is Chapter 64 of the Code of Criminal Procedure, which essentially says they have to still have it. The defense has to prove a probability of exculpatory result, and that there's still a manner and method to test it that's different from what was available at the time of the prior hearing.
And that different than what's available is probably the key.
That is actually the easiest standard to make now.
Do we get new tests?
Because the FBI has substantially altered their testing protocols.
Oh, okay.
Since 2016.
Oh, wow.
When they bumped the number of loci that they use for DNA comparison from 12 to 17.
Okay. So this could be, if it's a pre-2016 case, they could have proved that.
Yes.
Okay. So that's the easy part. But if you plea,
especially if you plea and you confess, the probability of exculpatory result is going to be a high bar to get to.
So this is basically that is what they decided on the exculpatory part, because if you confess, then how could it be?
Yeah, we're gonna make you stand by that confession.
Fair enough. All right. Merits cases and PDRs.
Yes, merits cases. These now that we're through the writs and the death penalty cases, now we get to the fun stuff.
All right. I'm sure they're all beautifully written and right on point.
Yeah.
All right, Harold Holoman.
Harold Holoman. Okay, this is one that was one of mine. So I'm going to run through.
Bragging. This guy bragging.
I do. I mean, all I do is win.
Oh, you won this one, so it's a good one.
I did. This is a good one. This is one where defendant was charged with family violence strangulation. He had a prior family violence that was not included in the indictment. So they only indicted it as the third-degree occlusion/strangulation. They did not indict it as family violence with prior, which is important because he got acquitted of the strangulation and got convicted of the misdemeanor family violence
just an assault family violence. So
correct.
This is just a standard. We don't think you choked her or impeded her breath, but you did probably put your hands on her.
Yes. So they convict him of the Class A misdemeanor. Punishment range for a Class A misdemeanor is not more than a year in jail, not more than a $4,000 fine. During punishment, the state proved up the prior family violence, and arguing a leva, which we chatted about earlier, it said, trial court judge, we're allowed to prove up this punishment enhancement during punishment. Punish him as a habitual felon under 1242D. And the trial court judge goes, he got convicted of a misdemeanor, but you proved up the thing you didn't indict during punishment. So yeah, 25-year sentence for a Class A misdemeanor.
Again, I mean, this is a case that shouldn't be there.
Yes.
Like who does that? Like what are you talking about? He got convicted of a misdemeanor. Just do the misdemeanor thing.
Yes.
Like, you decided you're just going to go above and beyond and do a previous. So what was he sentenced to?
So sentenced to 25 years.
Jesus Christ.
The Tyler Court of Appeals in a 6-page opinion says, Judge, you can't do that.
Yeah, you're convicted of a misdemeanor.
You don't get to get punished as a felon.
The misdemeanor has a set punishment range.
Yes.
If you're convicted of a felony, then you have a set punishment range. If you're convicted of continuous, then you have a set punishment range. There's no way they thought.
Yeah. So the state prosecuting attorney.
What the appeals court said. This is
the CCA opinion. The state prosecuting attorney's office took this up and said, "Hey, under a leva, we should be able to prove up a prior family violence during punishment, because it's punishment enhancement. It's not an element of the offense." Well, it's an element of the offense because it's something you have to include in your indictment, which is why it's important that they didn't indict it that way.
Yeah, because all I think of this opening up is, I get a guy for child sex assault.
Mm-hmm.
He gets convicted of child sex assault, and then the punishment range I get a 25 minimum because I proved that he did it before in punishment, which is a different standard with a different set of things. And so now I got I get a 25 minimum. See what I'm saying?
That was the state's argument. Yes,
that's crazy.
That you
that's
could prove
crazy.
Was that you could prove
bananas.
An element of the offense during punishment.
So did the appeals court overturn it, and then this was...
No, the Court of Appeals, the Tyler Court of Appeals, vacated the 25-year sentence and remanded for resentencing as misdemeanor.
Okay.
The state prosecuting attorney's office took it up and said, we should be able to do it this way because look at Oliva, where the prior is not an element, and the defense attorney filed the most god-awful abomination of a brief that I've ever seen.
I saw that.
39 words in the argument section without a single citation to authority.
I've seen those before.
I came across this case while I was prepping the 2020 case law update while it was pending. It had been argued and was pending, and filed an amicus brief on behalf of the Dallas and Denton Criminal Defense Lawyers Associations that essentially said, guys, whoa. You can't punish a misdemeanor as a felony. All of the punishment schemes in Texas are defined by statute. If the legislature wants to create a way for a misdemeanor to be punished as a felony, that is a legislative prerogative. It is not a judicial one.
Well, again, I'm glad that there's at least some appeals court out there who are willing to ignore the incompetence of a defense attorney appealing and actually find it. That gives me some. I like that.
Yeah, I don't.
I was about to say, if appeals court that, I might start losing faith in our justice system.
Yes. So this is one that went our way. If they're going to prove up the prior for purposes of making it a third degree, they have to indict the prior.
But again, I don't know if that's a win. It's like a win for this guy, but it's just that's what everyone thought. Nobody thought that.
Yeah,
if you told this at any prosecutor or defense attorney CLE, they'd be like, wait, what? What are you talking about, you crazy person? You can't do that. You can't send somebody to jail for 25 years when they've been convicted on a misdemeanor.
Yes.
All right, next, Watkins. Another one, mine. Counsel record. You see that?
See this? See this? This is me.
Counsel record.
Watkins was the discoveries case that has been pending in the CCA for forever and ever. As you can see from the 1016, this was decided by this was tried in 2015, appealed in 2016, decided by the CCA finally in 2021. This is the longest non-death penalty opinion of the term, and it goes to what material means for purposes of Article 3914. The long and short.
So this is MMA. What is material?
Yes.
That's why. So we're getting down to
Yes, and the
nitty gritty.
The quick and dirty summary is if the state's going to use it, it's material.
Yeah, because we went from exculpatory, right, to material, and now we're hopefully going still that direction and figuring out that pretty much everything is material.
Yes, if the state's going to use it, the state has to disclose it, is functionally what this opinion says. This opinion is worth a read, especially for those of you that try a bunch of cases, because you have Judge Newell and Judge Urey write the majority of the statutory interpretation cases that come out of the CCA. This case is everything you need to know about how Judge Newell is going to look at a statute, how he's going to interpret a statute, how he's going to break down a statute. Majority opinion on this case came down to approximately 53 pages, and he breaks down every piece of here's how we get here. Here are the arguments you should be making when you're dealing with the statutory interpretation issue.
And also, it could help you write your 3914 request, correct?
Yes, because one of the things that is still pending and is still out there is a case that was remanded in 2020 that has not made its way back to the CCA yet, was State v. Heath, which is how specific your 3914 request has to be to create a disclosure duty for the state. And
so, but this will help you until that gets decided, help you write your 3914 so that you can be sure from here on out that you have an appeal if they didn't reveal something.
Yes, the long and short on this is be as specific as possible. Without being so specific that you accidentally exclude things that might be there that you weren't specifically including.
And so you should probably have an individual one for, say, your blood cases, maybe an individual one for your
yes.
For your testing cases, like marijuana testing and stuff
I have separate 3914 requests for cases with DNA, case with blood, case with controlled substance, cases with possible out-of-state judgments or out-of-state priors, and all of my possible habitual offenders.
Okay. So get on that. Go read PD 1015-18 and get your MMA or your 3914 requests up to snuff. Ortiz, Orlando, and Barrett Dewey. So this is 2 cases, but essentially the same set of facts.
Yes, this is 2 consolidated cases that the court took on its own motion. This actually touches back to Holoman, where Holoman got convicted, was indicted for the occlusion and convicted of the lesser. These 2 cases say that the assault bodily injury is not a lesser of assault occlusion.
Oh, okay.
So fun story, those ones that they're alleging strangulation, they don't have a misdemeanor lesser included.
Wait, I'm confused.
Yeah, so am I. I don't have any idea. I mean, Simone Biles is jealous of how the court gets here. The kind of gymnastics necessary for an assault to not be a lesser included of an assault is.
So let's go back to Holoman. What am I missing? How did that happen? How did Holoman happen?
This was decided after Holoman. Holoman got convicted of the lesser back when he was originally convicted, so back 2017, 2018.
Well, okay, so hold on. I just want to make this clear because this is obviously important. If my client has assault, bodily injury with the strangulation, that's what we're talking about,
yes.
Right? And they don't find there was a strangulation.
Yes.
That's a not guilty?
Correct.
That's not a lesser included?
Correct.
See, I had no clue.
The mental gymnastics necessary to get there, considering
I want to read this one. I'm going to go and read this one. That's crazy.
Yes.
I want to see that. I prefer to read the ones where it doesn't make any sense.
This
is funner to me.
This is one of those ones where I'm like, guys, assault is a 2201 offense. So how is a 2201 offense not a lesser of a more serious 2201 offense?
This is a CCA decision?
It is, yes.
So it's done.
It is done.
Okay, all right, there you go. Hey, you know what? I'm just gonna say this is good news. So tell me about our instructions now.
You don't get the lesser included instruction.
You don't want the lesser included instruction.
That was how this was decided. This was decided on the jury charge, whether it was error to include or exclude the lesser included. There's no lesser included in the jury charge anymore.
But on the instruction. Are we getting an instruction that if you find that there was no strangulation, that it's a not guilty? That would be my question.
That might tiptoe into a comment on the weight of the evidence, but that's absolutely what you're arguing.
Okay. That's interesting. That's what we're going to argue, right? That something in there about that there's not guilty if they find that there was not strangulation.
Yep.
Could you try maybe even trying to get it? I mean, we can't do the questions anymore, right? I mean, so there's not going to be like do you find strangulation, right?
Yep.
Okay, that's an interesting one. I wonder if I'd like to see how we're doing that now. And is there any guidance to the judges about that?
Nope.
All right. Next, Isaac Williams.
This one is pending rehearing. So this is not a final decision yet by the CCA. But this one is particularly messy because it's a jury charge issue that kind of upends the preservation analysis under Almanza. What this one says is if the defense requests a lesser included, the defense has a burden of production on the record during the charge conference of identifying exactly what evidence supports the conviction for the lesser and exactly what evidence has to be rejected for the jury to get there.
So this is the jury instruction. We're trying to get a jury instruction, and it's now a burden for us.
Yes.
To to prove up the elements of the lesser included, or excuse me, I guess
to identify specifically the testimony that was presented that would justify the jury's decision to convict on just the lesser.
Okay.
And this creates a whole category separate and apart from unpreserved jury charge error that is specifically not reviewable. So now you have objected to jury charge error that's reviewed for some harm, unobjected to jury charge error that's reviewed for egregious harm, and then lesser included error that's whatever the fuck this is.
There you go. So now we're just opening up, and who does the judge decides that?
Yes, the trial court judge will decide on lesser included.
And
yes.
do they have to make the specific findings that there was no element as to that?
No, you just have to identify the testimony, and then the judge makes the either inclusion or exclusion from the jury charge.
What was the charge here?
This was a aggravated assault that they wanted the deadly conduct, if my memory is correct.
Okay. Gotcha. I was about to say, this is a specific thing, because like we were talking about, if it was a strangulation, which is not even a lesser included anymore, then I think we could argue that that it's there's going to be some that are held within there's nothing to prove, is what I'm saying for
yes.
this, right? So if it's an assault causing bodily injury versus a simple assault, I'm just going to use that as an example. And all you're determining is the bodily injury. Wait, that's still lesser included, right?
So far.
So anyways, the bodily injury, if that survives, all you have to argue is there was testimony that there was not bodily injury, or
yes.
I questioned them on the bodily injury. But it's going to be something more like the deadly conduct, maybe the what is it? I don't know. There's not going to be many.
No, there's not, and it's one of those. The motion for rehearing on this was filed back in June, and as of, now we're to mid-October, has not been ruled on yet. So there's at least a chance that they're going to significantly alter or withdraw this opinion.
Okay, all right.
As they should, because they've created a mess that there's literally no precedent for this requirement.
Yeah, it's a weird one. I can't figure out what it's going to affect off the top of my head. I'd have to think about it.
The interesting piece is this is specifically a one-sided burden, is that this presents no requirement that the state present the same evidence when the state requests a lesser included. And I've actually got that issue going up to the Second Court of Appeals right now on a continuous sex assault case where I objected to the state's request for lessers. On an all-or-nothing trial strategy.
Oh, okay. So, but this is something that they should pay attention to. You should pay attention to if you didn't want lessers.
Yes.
And you got lessers, then let's.
Yeah, this creates a whole new secondary preservation argument for inappropriate lessers that the state requests.
Gotcha. Okay. Fair enough. All right, that makes sense. All right. So, but this decision doesn't touch on that. But one would assume, if we were to use logic, which we're not accusing any of the higher courts of doing, but if we were to use logic, that it should be on the prosecution also, correct?
Yes.
But that's not in this case. This is defense.
Yes.
All right. Go over here and click. Marvin Rodriguez.
This is confession and avoidance for purposes of a self-defense jury charge. The predominant issues here were the voluntary act requirement and the kind of admission of guilt requirement. This is one where there was some dispute as to whether the shooting was a voluntary act, and the court said, look, even an accident can be voluntary. The standard for voluntariness is real low.
Okay, so this is important because we face this quite a bit. This is about the self-defense, right?
Yes.
This is the core of the self-defense, which is you have to admit to get the self-defense instruction, correct?
Yes.
And so that's an issue that I think everybody who has these cases struggles with,
yes.
right? It's really trouble when you got hey, they didn't do it, but even if they did, it's a self-defense, and now I don't get a self-defense. All I get is that they didn't do it.
Yes.
Counterintuitive and tough to think about and tough to deal with our clients when we're talking about it with them. And so this one touches on that. And so apparently this guy did it right.
This guy got about as close to the line as you can get.
Okay. So basically he testified.
He testified.
He says, it was an accident.
Yes.
And so then obviously the DA was like, hey, he said it was an accident. He never properly allocated it. He never got to the confession part of this. So he shouldn't get the instruction for the self-defense. They did give him the instruction, obviously.
They did not give.
Oh, they did not give him the instruction, and the CCA says should have gotten the instruction.
No, I take that back. No, he did not get the instruction.
Okay, but they're saying he should have.
Yes.
Okay, so definitely look at this case as to the exact nature of how to do it. Right?
Yes, and that's the next slide.
We're going to touch on it. There we go.
The voluntary act requirement in the mental state is essentially, they said, pointing a loaded gun at somebody, good enough. Even if you say it was an accident and I didn't mean to, good enough. Voluntary act requirement, even if it was an accident, your finger was on the trigger, that's good enough.
Okay. And so this was about voluntariness, not necessarily self-defense. Is that correct?
No, the voluntariness was the piece that went to the
self-defense instruction.
To the confession and avoidance piece. Okay. He says it was an accident and he didn't mean to shoot him. But
if he did, it was self-defense, which we all want to use. That's what we want to use. But the problem we all face is getting our guy in front of there, and then he confesses to doing it, and then the jury doesn't buy the self-defense, even though something like this, that he's saying it was an accident, but even if it wasn't an accident, I had self-defense.
Yeah.
So this allows that to some degree. So this would be a good decision to go through and look at and see what the exact wording was.
If your testimony is going to be real close to the line on confession and avoidance, this is one that's worth reading.
Yeah, and this is worth reading to see what the testimony will be. what you need. This is what you need in order to put your guy on the stand, right?
Yes.
Okay. Another two-parter, Christopher Sims.
This is one where honestly I think the court gets this one wrong, which is very rare for me to say when the defendant wins.
This is another deadly conduct.
This
lesser included.
Yes.
Aggravated assault.
Yeah, this is an aggravated assault where driver was speeding, passes out while speeding, car crosses the center line, hits another vehicle head on, killing the driver. Defense argues for the lesser included, essentially saying, hey, there was no voluntary act, he passed out. The way they indicted this case, and this is important, is they indicted the reckless act as the speeding.
Okay.
They did not indict the crossing the center line was not the reckless act. It was the speeding that was indicted. And he was speeding before he passed out. So the fact that he passed out has nothing to do with whether or not he was speeding. So the Court of Criminal Appeals in this one says, we don't think there was a voluntary act. He passed out. That's not a voluntary act. You should have gotten the lesser included. The dissent says, guys, what the fuck? They didn't indict for crossing the center line. They indicted for speeding. He admitted he was speeding, and he was speeding before he passed out. There's no lesser on these facts. And I think the dissent's right.
But how does this square with the previous holding of proving that? So this is kind of already addressing the proving the lesser included, right? So essentially, what they said in the other case, I forget the name of that one, but that the defense has the burden of getting there, where these guys got. Mm-hmm. And now they're saying that...
And this is an absolute masterclass. I mean, it's hard to win in the CCA.
Yeah.
It's real goddamn hard to win in the CCA when you're wrong on the law.
This doesn't say mine. It's not yours.
It was not mine.
I don't know why you're packing on somebody else.
I am super impressed that not only did they manage to win in the CCA, but they managed to win on something that's both factually and legally inaccurate.
Yeah, so that's awesome. Good job.
So like, man, I am impressed. But the dissent got this one right.
Yeah. But
specifically because of the way this one was indicted.
But this is good news for the previous of if we do have the burden as defense attorneys, then this is good news for that. At least they're giving some leeway as to what that burden is, relieving some of that burden. Right?
Yeah. Well, this was decided. I believe this one was decided
before. It doesn't matter. Doesn't matter. They're both
Williams.
decided. They're both in there. Right? They're both in there.
Yeah, yes, but they're not going to retroactively apply a jury charge argument to something that was pending on appeal at the time the appeal was filed.
That's true. I see. So you're saying this could have been technically already overridden?
Or
the other one?
I mean, this one, this is obviously one where the defense attorney did a very good job of laying out what the testimony was to try, like, what the theories were and what the testimony was and why they should get to the lesser.
And so why we got 2 for 2?
This is where I talk about the indictment.
Okay.
Is the indictment on this case alleged the reckless act was the speeding. So the voluntary act has to go to the speeding. And he testified that he was speeding. So he testified to the voluntary act. So if there were any kind of confession and avoidance defensive issues, he would be entitled to that jury instruction.
Okay.
Since here we're dealing with the lesser included, which goes to mental state, not to confession and avoidance, he was already speeding when he passed out. If they had alleged the lane change as the reckless act that resulted in serious bodily injury causing death, then this would be right. The majority
right. It's the CCA, man.
The majority opinion,
right.
The majority opinion would be correct had the state indicted on that theory.
Gotcha.
The majority opinion in this case decides this case on a theory that wasn't indicted.
But the jury found for it, right? The jury went for it, or we wouldn't be here.
No, this is one where they'd refused the lesser. I believe they'd refused the lesser included.
Oh well, then never mind. Well, then I get you. Okay.
Because this is one where they reverse it for not including the lesser included.
Oh, so they refused. Oh, so they're saying they should have
included the lesser included.
Okay.
And that's why I think they got it wrong.
All right.
On these facts with this indictment, that's not the right outcome.
Well, but if you're right, it won't matter.
Correct.
Because the jury will say that had nothing to do with it. Correct?
Probably.
Unless he gets this defense attorney who's pretty good. He might be able to convince him. All right, Anthony Carter.
Anthony Carter. This is a fascinating case for those of y'all that do drug work. This is...
like dealing?
Defending the dealers.
Oh, my bad.
This is one where it's a case out of Lubbock where the smoke shop owner was selling Chili Willy, which tested positive for fluoro-ADB, which is a penalty group 2 controlled substance. All right,
so Chili Willy.
Chili was synthetic marijuana.
Being the spice, what we would call spice.
Spice, kush, whatever.
Yeah.
This case is interesting because there's a big overlap between the stuff that's specifically identified, especially some of the synthetic marijuana fluoro compounds in penalty group 1, and the way that the state legislature changed penalty group 2 back in 2015 to account for molecular structure as opposed to product name.
Yeah, so this is all the synthetic drug stuff, which is, for those who don't know, essentially we had a very strict definition, as I think we should, of what these drugs are what these substances are.
Yes.
Because we're calling them drugs that are drugs. So essentially, tetranine, hydrocannabinoid, is a specific thing. Delta-9 tetrahydrocannabinoid is a specific thing. Delta-8 is different. And so what these very smart, and by the way, this is all the internet because these people can share it. And so basically this one guy who is a genius wrote a ton of stuff. He wrote 2 huge books on chemistry on how to create one-off substances. Mm-hmm. So sure, you like acid? Okay, it's illegal. Lysergic acid is illegal, but we have this chemical where we take off an O here and add an H here, and it's a different chemical, and you test differently. You can say this is not lysergic acid, and then it's legal. Mm-hmm. So obviously with the advent of the internet and everyone getting a hold of these and figuring out how to make them and the spread of knowledge, they had to change things. So they started they started changing the law to incorporate these synthetics, bath salts as being the big push,
Yes, and the idea here was that they made specific molecular structures, particularly common molecular structures, illegal to bypass the requirement of having to say, okay, it's this 50 character chemical designation, but not this 51 character chemical designation. Now they're just like, fuck it. If it's got a hydrogen ring connected to a nitrogen ring at this point, it's illegal.
So essentially, they just again tried to group it instead of being specific.
Yes.
But in grouping it, they actually incorporated a lot of standard chemicals, and it just creates a lot of problems. It is what it is. So now this guy was selling one of those in his fake Kush, which seems to be kind of, they seemed like they were on point. So what did the CCA say?
Yeah, let's skip over to the next slide. And what this one is this went up on a sufficiency of the evidence argument, and the CCA essentially says, okay, look, the jury can conclude from the expert's testimony that this is what the state says it is. But they were very careful not to get deep in the weeds in the chemistry, because the testimony as far as the actual chemical makeup for these PG2, PG2A substances was pretty lacking. The interesting piece of this is that for purposes of the Health and Safety Code is the 2015 amendments that created the molecular designation of illegal chemicals are probably going to be considered later in time than the contemporaneous classification of some of those in PG1. So there's a...
so basically what you're saying is there's a conflict between the 2015 amendment, which talks about the chemical groups, and
some of the specific listings in Penalty Group 1,
which use common names for those chemicals.
Yes. Okay. And because the difference between a Penalty Group 2A substance and Penalty Group 1 substance is significant in punishment terms, keep in mind your Penalty Group 2As are your synthetic marijuanas that are charged on the leaf marijuana scale. So under 2 ounces, 2 to 4 ounces, 4 ounces, 5 pounds, 5 to 50 pounds, etc. The punishment range for those tracks, for those PG2A groups, tracks leaf marijuana, where your punishment group for your Penalty Group 1 controlled substances is state jail plus automatic. So there's
it's crazy because the leafy stuff, the synthetic marijuana is generally just hemp sprayed with these chemicals. It's just like the Delta 8. It's not, they didn't create a new marijuana. That would still be illegal. Yes. So what they do is they take the legal marijuana, which is now legal, which is hemp. They take the flowers from that and they spray it with these chemicals that are derived from hemp, but have been so concentrated on these specific things, in this case Delta 8 or Delta 10. And so basically what this creates a conflict. So those are weighed according to the marijuana scale.
Yes.
Which is weird because you could spray as much chemical as you want on the same amount of hemp and it'll get more powerful, but your PG group won't change unless you add more hemp.
Yeah, so since there's a conflict, you can make an argument that the molecular structure designation supersedes the specific name designation to remove what would otherwise be a Penalty Group 1 controlled substance and make it a Penalty Group 2 or 2A controlled substance. Penalty Group 2.
So essentially,
you're looking at a major Penalty Group reclassification as far as your punishment range goes. And since it's an offense outside the penal code, because these are defined in the Health and Safety Code, the rule of lenity applies and would support that lowering the punishment range.
So what you're saying is, in the Penalty Group 1, there's a name for something, but in the 2015 amendment, they kind of classify that as something different because it's a part of another chemical group.
Yes.
And so essentially, we have a conflict, and therefore the argument would be you're going to lower it down. Now again, come on, man. There's no way the CCA is intelligent enough to parse that out. Come on, maybe
that's why this went up as a sufficiency of the evidence argument.
That's right,
and not as a chemistry argument.
There you go. And again, you have a note here that the constitutional agreement or argument surrounding PGA 2 is that now with the 2015 amendments, PGA 2 becomes essentially you don't know what's illegal.
Yes, you could make a void for vagueness argument because you need a chemistry degree to figure out what some of this shit applies to.
What is illegal? But did they not make that argument here?
I don't believe so. No. If they did, it was not an issue that they granted PDR for.
Okay, but essentially what they said is the new 2000 amendment supersedes that, and so what we're saying is pay attention to that if you do a lot of very high-level drug work, because you could have an argument that a PG1 is actually a PG2.
Yes.
All right, that's awesome. All right, Juan Flores.
Juan Flores is an interesting one. This is a ag assault deadly weapon where the alleged deadly weapon was a drill that the defendant never tried to drill or stab or cut or never made any offensive use of the drill.
So in other words, he didn't use the drill as a weapon.
Correct.
He just had a drill.
And the CCA here says the conclusory testimony that that's a deadly weapon is not good enough. Vacated the deadly weapon finding.
Okay. So probably, like, what did he, was this a robbery?
It was a robbery, yes.
Okay. So he was holding a drill. They did the deadly weapon finding instead of just the regular robbery finding. And they're saying that if he didn't use the drill, like,
yes,
you get off. Is that correct?
Yeah, no evidence that the drill was used or intended to be used in a manner that was capable of causing death or serious bodily injury.
Okay, so this is just outlining what a deadly weapon is that we do have trouble with.
Yeah. Now, the interesting piece of this is going to be whether they apply this to firearms and whether the state will have to prove up that the firearm was functional as required, as it's defined in Chapter 46 for a deadly weapon firearm finding.
Listen, as good as this is...
I don't think they're going there, but it's going to be an interesting argument.
All I want is for us to stop having fists as a deadly weapon. If you're going to talk some logic about a deadly weapon, how about my fists can be, like, literally the opposite of a deadly weapon can be a deadly weapon. A deadly weapon is, and again, there's no way this comports with the logic of having fists as a deadly weapon. It doesn't make any sense, because if I don't have a weapon, that's literally a deadly weapon is like, look, there's serious bodily injury. Mm-hmm. That's one thing. We have that, serious bodily injury. But then you say, if I cause serious bodily injury, that no weapon, literally no weapon by definition. If you were to say, does he have a weapon? You would have to say no. He does not have a weapon. He has his hands, which he can use to assault
Are you telling me
people.
you ain't got the guns?
I got the guns. I'm a Brazilian Jiu-Jitsu black belt. I don't know if you know that. These are registered as deadly. No, that's what everybody said as I was growing up. Black belts, these were deadly weapons. Well, we don't even do that in Jiu-Jitsu. But my point is, I'm just saying that's the definition of a weapon. And somehow these are still in the definition of a weapon, right? I'm not missing that. I've seen that. Literally, I've seen guys convicted of deadly weapon. That's separate from serious bodily injury. I don't understand how, with the drill, I guess they're saying, because if I use my hands to try and kill someone, they become deadly weapons, and this guy didn't drill it, so maybe it can comport, but it's just crazy to me. You can't get me until that's one of those that I'm not going down that road. It doesn't make any sense. I'm glad they did decide this. Keep that in mind when your guy has something that he never intended to use a deadly weapon. Now we're down to the BB guns, right? Where if it's an airsoft, it's not a deadly weapon, right? So far. That's my understanding. But if it's like a BB gun, like a CO2 with metal BBs, mm-hmm. It can get up to deadly weapon, yes. Right? And what if it's a BB gun that I didn't ever threaten? Is that...
that's why I say it's going to be interesting to see what they do with firearms, yeah. Because there's no way. Statutory definition of a firearm is enough of a gray area so that you could arguably apply it to things like airsoft or
correct,
BB guns.
but I think I would imagine this argument is that a drill is just a drill.
Yes.
And if it's just like having fists.
Yeah, and it's one of those ones where, I mean, the dispositive factor here is that the defendant never attempted to strike anybody
or drill anybody or, I'll give me your money. To be fair, okay, you know what? I'm arguing against myself because now here's what I'll say. What they're saying is fists are just fists until you use them as a deadly weapon, and a drill is just a drill until you use a deadly weapon. I'm going back on everything I said. That's fair. All right. Next.
Lujan, this is a Miranda case related to a murder. A woman gets arrested, gives a statement at the police department. That's statement number one. Then the detectives leave for a little bit, and they come back and they say, hey, like, we'd like for you to show us some stuff, kind of help corroborate your story. So we're going to take you out of the police station. We're going to put you in the police car. We're going to
drive you around.
We're going to drive you around, see what, show us that you're not lying to us.
Point some people out, point some places out, show us where you did it.
So they make a surreptitious recording of the conversation in the police car while she's taking them around and confessing to
after she's waived her rights?
In a murder. No, she was not
This is all you're free to go?
She was not re-Mirandized in the police car.
Okay.
So they make a surreptitious recording where she makes a whole fuck ton of incriminating statements. Then they take her back to the police station, stick her back in the interview room. Again, do not Mirandize her. They don't re-Mirandize her when they take her back to the police station. They pull out the iPad and they play the recorded conversation, and she gives them more incriminating statements because she's like, "Well, fuck it, you got me." So the court threw out the second and third. The trial court threw out the second and third statements. The statement in the car and the statement that they got after using the statement from the car, but let the first Mirandize statement end.
At trial?
Yes.
Okay.
Specifically because she'd been properly Mirandized the first time, and they said that the intentional misleading nature of removing her and terminating the interview and making her think that they were not recording the interview made the second one and anything they used the second one to get inadmissible.
And that's fair. So
yes.
The trial court kind of ruled on we would...
Yeah, Court of Appeals sends it back, says, nope, all those statements are admissible.
Whoa.
CCA goes, hold on, guys. Whoa, you gotta record. Like, there's a very specific requirement for 3822, and it's warn, and then give a statement, and then they can use the statement. And those three things have to appear in the recording.
Okay. So this is correcting the Court of Appeals, not the trial court.
Yes.
Trial court got it right. Court of Appeals reversed it. And now the CCA is saying, you can't do that. They're back to what we would think.
Yeah, and this is not new. I mean, the case they cite for this proposition is Osborne was a CCA case from 2007 or 8.
Yeah.
Saying
the same thing.
Yeah, this is not new.
You can't use one waiver of rights to then go and pounce all over them. It's not free reign. You can't then trick them and say, all right, well, this isn't recorded, or even just record other stuff. You got to read them the rights every time you start a new one, right? Essentially what you got to do.
Yep.
All right, we already knew that. Chase Wheeler.
This is a case where I will give the officer credit for this. He is unreasonably honest in his testimony.
I saw this recently with a former DPS blood analyst.
Yeah, this is one where it's a young police officer on the force, maybe 16 months at the time of trial. And this is a case where he made a DWI arrest, applied for a search warrant, didn't swear out the search warrant affidavit to get the blood draw. Well, that's a problem because search warrant affidavits had to be sworn. Well, not only was his not, he testified that in the entirety of the time he worked for the police department, he had never sworn out a blood warrant. Never. And that's one of those
guys, pay attention. Go back and read. You might.
And that's one of those ones where I'm sure everybody in the courtroom just turned and looked at each other and they said, "What?"
No, that's when I watched this. I watched a case. It was a DWI case here in Denton County, and when I watched it, and she testified. I'm not gonna mention her by name, but she's popular. She worked for DPS for a long time doing these cases.
Yeah.
But then she said, "No, I didn't swear. I didn't take the oath and swear." And everybody was just like nobody saw it coming. The defense attorney was floored. They're all like, "Wait, what just happened?"
Yeah.
So
the trial court denies the motion to suppress. finding good faith exception applies. Court of Appeals, Second Court of Appeals, reversed.
They're trying to say good faith on him taking the oath.
Yeah, good faith exception. You didn't know you had to do this. And the Second Court of Appeals is like, guys, what the fuck? No. There's no more obvious requirement than the sworn affidavit has to be sworn. It's in the fucking name.
Yeah, because again, we could look as defense attorney, any attorneys, forget defense attorneys, family law attorneys, we could be like, oh, we didn't know that had to be sworn.
Yeah, going back to 2014, this is the only guilty plea the Second Court of Appeals has reversed on appeal.
Really?
Yes.
Nice.
So this is this is a unicorn of a case. So the CCA affirms the Court of Appeals reversing the denial of the motion to suppress.
Okay. So this is one motion. This is a motion to suppress. Pled guilty, and then, but I'm guessing they reserve the right to appeal.
Yes.
Okay.
It's objectively unreasonable to think that executing a search warrant that wasn't supported by a sworn affidavit. Absolutely no objective good faith here. Yeah. No good faith exception.
All right, Villafranco.
This is a sex case. This goes to the procedural requirements for conducting Rule 412 hearing before using prior sexual history of a witness.
What's the Rule 412?
The Rule 412 is the slut shaming rule where you don't get to get into sexual history of a victim of sex assault. Okay. Unless you can show that it is constitutionally necessary, i.e. there's some kind of possible exculpatory issue there.
Such as she's accused 3 other people of similar stuff and then found out that they were.
So this one's weird because as a general rule, in this case, the court completely mangled the 412 hearing. The Court of Appeals didn't do a great job of trying to fix it. Which would usually mean that this has been waived and fuck you, because you're a rapist and fuck you.
They mangled it. Did they let it in, or
they kept? Not only did they keep it all out, but they also screwed up the procedure for doing the 412 hearing.
Gotcha. Okay.
And that's what went up to the CCA. Is the CCA says, hey, where they screw up this badly on conducting the 412 hearing, because the 412 hearing is outside the presence of the jury with the defendant, the state, and the victim, and you essentially get to run through, hey, this is what we want to get into, and this is why we think we can get into it. And that's supposed to be on the record outside the presence of the jury so that the Court of Appeals can review that for error if the court excludes something they shouldn't have.
I guess it wasn't on the record.
It was not on the record. And usually the court would just say, you didn't preserve it, so fuck off and go to prison. In this case, they said that the appropriate remedy...
Did the defense attorney object to that?
I would assume so, yes.
Okay, cool.
But the appropriate remedy in this case is not finding a forfeiture, it's remand, reopening proceedings, having the 412 hearing, and then adding the 412 hearing to the record so that the Court of Appeals can review the 412 hearing in the context of the trial.
A separate 412 hearing?
Yes. It's the proper remedy is abate the appeal, send it back, have the 412 hearing, supplement the record, and then the Court of Appeals decides the issue.
And did they do that, or they're doing it?
That is a new rule after Villafranco, requiring abatement and supplementation of the record.
With the same jury?
No, that's...
you don't have to do a jury because you do it outside the presence of the jury. So you just go back to the judge and redo it.
Yes.
Just redo the 412.
Yep.
Wait, and so then... So time out.
So
then, if the judge did the right thing the first time, if he reaffirms himself...
Yeah. So at that point, what you're doing is you're saying this is the evidence that the jury should have been able to hear, and so the Court of Appeals has that for making a determination of harm.
So let's say the judge reaffirms himself. You can then go and say the judge shouldn't have, and that's an abuse of discretion?
It's admission or exclusion of evidence is abuse of discretion,
So basically...
Good luck.
Yeah, good luck. All right, yeah, you're going to get a hearing.
I am amazed they didn't find either waiver for not making that record in the first instance, or failure to preserve for not making that record in the first instance.
They got to give us something once in a while. That's all I got to say. They got to give us something. Okay. Juan Macedo.
This guy was this is a misdemeanor trial where they let in police records that are specifically not admissible under 803 sub 6. police reports related to extraneous offenses, and the CCA was like, this guy was a perpetual shithead. It couldn't have possibly had that much of an effect on the misdemeanor punishment that he got. We don't care.
Okay, so this is just basically...
Yeah, where your guys got 20-some-odd priors, the CCA is not going to care if two of them were admitted.
So he didn't get a new hearing in
he
this
did
one.
not.
All right. Dolan and Holoman.
Holoman is going to be the one to watch for the local practitioners up this way.
This is the time payment stuff again?
No, Holoman was the one that was vacated back to the Second Court of Appeals for analysis after Watkins.
Okay.
As the second was inclined to take a...
Wait, Watkins was yours?
Yes, was the 3914 case.
He didn't have it up.
The Holoman was not one of mine. This is one that they sent back because the Second Court of Appeals was following Waco, which is who was reversed in Watkins on 3914 means the same thing as it always did, is material exculpatory Brady. They sent Holoman back to see if that's material after Watkins. And then Dolan is one of multiple cases that was decided on the time payment fee.
That's what I was saying. I was about to say, there is a time payment thing here. I remember that from the legislature.
Yes.
It was like 100 of our legislators. They went and fixed it.
Yes. Is the time payment fee is essentially, since the fees aren't being paid while the appeal is pending because the case isn't final yet, you don't get to contest the time payment fee on direct appeal because it hasn't been assessed.
And they fixed this.
Yes, this is one of a number of things that the legislature fixed.
We're done. So, I mean, it's good to know if you have a past case, but they passed a lot, right?
Yes.
So, all right. Dorsey?
Dorsey is whether you can waive a double jeopardy violation by pleading guilty to two offenses that violate double jeopardy when considered together.
All right.
And that's been remanded for further briefing on the court's jurisdiction to hear that argument, or whether there's waiver in the first instance if you plead guilty to, say, two DWI with child cases arising from one offense. That says, hey, if you pled guilty to this, do we have jurisdiction? Like, explain to us how we have jurisdiction to hear this.
Gotcha. Well, it should be just dismissed.
Well, I'm not sure the vacate and remand for additional briefing on Dorsey was not specific as to whether the theory was they didn't have jurisdiction because the appellant had waived his right to appeal by entering a plea bargain, or if there was some other possible issue there.
Gotcha. But so that's just going back. We'll wait for that to come back.
Yes. I think what they're saying on that one is after Carson and Boyd, which are the two that say if you enter a plea bargain and waive your right to appeal, you don't...
can't appeal.
We're serious. When we say waived, we mean waived. You don't get to raise this. So I think that this is a jurisdictional issue related to the certification of right to appeal, where there was probably no right to appeal granted by the trial court.
And Sanchez.
Sanchez, if you were the prosecutor on a case, you cannot be the defense attorney on the same case.
What?
This isn't fucking hard. How do people keep screwing this up?
What?
Yes.
Are you crazy? Man, I don't know, because I was a prosecutor for like 6 months, and I knew even in that 6 months I couldn't represent somebody I just prosecuted.
Yes, no, you don't get to leave the DA's office and be like, "Hey, remember when I was prosecuting you? I know what the weaknesses in the case are."
That really happened.
Yeah.
This has to be a small town thing, right? Yeah. Jesus Christ. Okay. I think I skipped one. Cisneros.
This is a. This is a vacate. This is one where the guy got convicted on a metric shit ton of sex cases. The Court of Appeals vacated some of them for double jeopardy violations because they were lesser included with greater includeds. And the CCA sent this one back to the Court of Appeals and said, guys, figure this out. Like, what's he still convicted of? Because this doesn't make any damn sense.
So this was just a wholesale where they screwed up the paperwork.
Yes.
Right? They just were like, all right, here, plead to this. And he's like, yeah, I don't care. I get 2 years in jail. Whatever.
Yeah, this is one where he got convicted on ag sex and indecency, and I think a continuous sex assault. And since they're all included within the same, the CCA was like, guys, we can't tell what he's still convicted for and what you vacated, so do better paperwork.
Continuous, 25 to life. What's the problem? Okay, so they sent it back to get...
Yeah, they sent it back to do better work.
Gotcha. Daniel Barnes.
This is an unpublished case, another misdemeanor punishment case. Guys, Aryan Brotherhood. A whole bunch of stuff that shouldn't have come in on punishment came in on punishment, but he was a perpetual shithead and they didn't care.
Same thing before.
Yes.
This is just another one. Hey, guess what? If you got a whole bunch of felonies, they're not going to think that the fact that they offered a misdemeanor that they shouldn't is important.
Let's see. Woods. This is an ineffective assistance of counsel case on appeal. This is one where the appellate lawyer made some interesting arguments regarding the completeness of the clerk's record, but the clerk's record got supplemented before the Court of Appeals decided the case. So all of the issues that were raised were moot by the time the Court of Appeals decided it. So the Court of Appeals affirms, because there's literally nothing there. Everything had gotten fixed. So the defendant takes it up pro se on PDR and says, hey, I was denied effective assistance of counsel because he didn't raise anything. Everything had been fixed. And the CCA agreed and said, hey, like when everything gets fixed, you have a duty to supplement or file an Andrus brief. If you can't find anything, you at the very minimum have a duty to file an Andrus brief and say there's nothing here, send a copy to the client so the client can file something. So they vacated.
They didn't do that. They just left it as is.
So they vacated the Court of Appeals decision affirming the conviction and sent it back for rebriefing.
So it's just for appeals attorneys like yourself to know that if everything got addressed, you got to go file an Andrus brief at the very least, or find something else. You got to find something. Come on. No, I'm just. So this guy just didn't file an Andrus brief.
Correct.
And so then he's going to get another appeal. He doesn't get a new trial, right?
No, he gets a new appeal.
He gets a new appeal.
Appointment of new counsel.
So he gets a new counsel who's going to file an Andrus brief.
Probably, yes.
All right.
Najar. This is one where the jury heard a siren during deliberations. And the trial attorney, being inventive, said, "Judge, that's other evidence. Like they've heard something that could have affected their verdict." Trial court was like, "That's cute. No,
stop it.
That's interesting, but no." The Court of Appeals,
they switch it.
The Houston Court of Appeals vacated.
Saying that a
siren could be other evidence that
I'm gonna clap for this guy for just throwing it out there, and it stuck. And for a second, him and his client are like, "Yeah, high five, yeah, siren, dude! I told you the siren would work."
And then the CCA came back and said that's not other evidence under Appellate Rule Procedure 21.3 and vacated the Court of Appeals reversal and remanded the Court of Appeals for further consideration.
See, this is, no matter how stupid your idea, go ahead and throw it. Because your good ideas are probably as likely. Your stupid ideas are probably as likely as your good ideas.
The creative ideas are the things they haven't addressed before.
Yeah.
It's the stuff that everybody thinks of. There's already bad law on. It's the new stuff.
Hey, CCA, they could have, it's not that, we wouldn't be like, oh, that's crazy. Frederick Brown.
This is a forfeiture by wrongdoing issue where the court says just because it's family violence doesn't mean you have a lesser confrontation clause right. Apply the confrontation clause. Guys, this isn't hard.
This is for forfeiture, not the
this is
the
by
crime.
For forfeiture by wrongdoing. Yes,
gotcha.
This is the forfeiture by wrongdoing is where the state alleges that the defendant did something that made the witness unavailable, so they get to use the witness's statement.
Oh, the forfeiture of your right to confront.
Yes.
Okay, I was thinking material
you're thinking
forfeiture.
asset forfeiture.
Yeah, that's what I was thinking. I'm sorry,
Yeah,
but
no.
I've done this one. Okay, I've had these before.
Yeah, no, this is a confrontation clause issue where that's like, hey, the legislature has a whole bunch of things that they can do to make prosecuting these easier. The confrontation clause still applies. Apply the confrontation clause.
Yes.
Send it back.
Yeah. Okay. Cool. Because they basically let the statements come in when they shouldn't have, when there was no reason. Probably because the victim didn't want to, the complaining witness didn't want to show up to court, and so they somehow convinced. I had one war story. I had one where they brought the subpoena to the lady's work, so the complaining witness had her own job, her own place. They brought the subpoena to her work. They went to her boss, got in her boss's office, and handed her a subpoena in her boss's office so that she'd show up to this case. And she told her, "Go shove this up your ass." That is what they testified to. And then they came in saying, that must be the work of my client. He must have forced her at her work to tell you. So, yeah, I won that one, but this is something that...
Yeah.
Now, Harbin.
Harbin is one where the defendant almost got what he wanted. He was convicted back in 1991 for a murder charge on a subsequent writ of habeas corpus. His case was remanded for a new punishment hearing. At that new punishment hearing, he argued unsuccessfully that he should be entitled to a sudden passion instruction during punishment. Now, the problem is with his sudden passion argument is he was convicted originally in 1991. The sudden passion element as a mitigation issue was not added to the penal code until 1994. So the trial court said, sorry, bud, you're out of luck. You don't get law that wasn't law at the time that you committed this offense. The Court of Appeals was like, no, we disagree. We're inclined to give you the benefit of the change in law. And the CCA says, nope.
No way.
You don't get law that's not law at the time of the crime you were alleged to have committed.
Yeah, you can't. All right, fair enough.
We only make the state's job easier. We don't make the state's job harder.
Don't make it harder. Never, ever. That's if you're new. You know, everyone might. If you're new, they'll never make the state's job harder. They'll only make our job harder. But that makes us better lawyers, right? That's why we're better lawyers than them. All right, next up.
Curlee, this is evidentiary sufficiency for a drug-free zone enhancement. This was the drug-free zone was a public playground, and the only evidence that was a playground that was open to the public was the conclusory statement that that's playground. And you got to do just a little bit more, probably not a whole lot more, but just a little bit more than that for the drug-free zone enhancement.
So this is the old, I just went to pee at a park at night and they got me for a sex offense type thing. So this is basically, it has to be reasonable. Is it reasonable? Is there a standard now?
No, you have to have more than the mere conclusory statement that the park was open to the public.
So open to the public, no good. So now we got to go up the ladder and frame that down. Or prosecutors can just not prosecute it as a drug-free zone.
Yes.
If there were no kids around. That could happen. Or not. All right.
Becerra, this is a preservation of error issue where the court was, again, more lenient than I would otherwise have predicted. This is one where the alternate juror retired to the jury deliberation room and began deliberating with the jury. So there are 13 people back there instead of 12 people back there, which is exactly the kind of other evidence that's problematic.
There's the other evidence. Was there a siren? Was there a siren when the 13 were in there? That's the question.
So the question at this point becomes, as soon as the defense attorney found out that the 13th juror was back there, he objected. The question was, is that timely, or do you have to object at the moment that they retire, or can you make the objection when you find out that the alternate's back there deliberating? This case holds that you can make the objection when you find out that the 13th juror is back there deliberating.
Again, it's back to what we're talking about. It's one thing to not know, and it's another thing to know and not object. Those are two different things, for sure. So this one they got right.
Yes, and it's one of those ones where you will want to make sure, if you run across this problem, you will want to make sure that you've got a good record of how long they've been out, when you found out the 13th juror was back there, the timeliness with which the objection gets made, and you want all of that to be apparent in the transcript for the Court of Appeals.
So you got to say, Your Honor, they went back at X o'clock. I didn't find out for some reason. I heard that there was 13 in the back at X o'clock. I immediately, the minute I found out, I objected. I'm objecting now on the record, and I'm going to object strenuously and ask for a mistrial. Would that be the remedy here?
You can ask. You're probably not getting it.
But you want to ask, right?
Yes.
Okay. Did this person ask for a mistrial? Do you remember?
I did not have a chance to pull that transcript.
Okay.
The Court of Criminal Appeals opinion didn't indicate one way or the other.
Okay, so maybe it's not necessary. Better safe than sorry.
The mistrial is always a good idea for ensuring preservation.
Well, what was this attorney's remedy? what this attorney objected.
Mm-hmm.
What did he want then? For the 13th to leave the room?
Yes.
Would that be enough?
I mean, at that point, you've gotten what you wanted, so I don't know that you've preserved error.
Did the 13th leave the room at this point for
yes.
this?
Yes.
Okay. All right. So, but regardless, do your due diligence, put it on the record, and then maybe they'll remand back for the merits of the issue.
Yes.
And let the jury deliberate with only 12 people. Is that what's going to happen?
That's what should happen.
Okay. Jesse Martinez.
Oh, Martinez. Oh, this is a police misconduct case where the Martinez is a suspect in murder case. He goes down to the police station voluntarily, cooperates for a little bit, then decides maybe I fucked up here. Maybe I need a lawyer. So after a partial voluntary interview, he then invokes his right to counsel. He goes from being free to leave and being treated with a modicum of respect by the police to being chained to the table, denied food and water, and
left for hours,
viciously interrogated for a long period of time.
Yes. After
invocation of his right to counsel. The Court of Appeals makes an absolute clusterfuck of the Brown factors, which are...
Now, Brown is where... you can turn an illegal arrest into a valid confession. Is that correct?
Yes, and that's essentially when you give Miranda, how close in time the arrest without Miranda and the confession are, any intervening circumstances, and the flagrancy of the misconduct.
Okay, and those are the 4 factors, and you're saying they didn't do a perfect job.
They did not, and the way that the Court of Appeals looked at this case was the first factor weighed in favor of the state because he was given Miranda at the beginning of his videotaped interview. Setting aside, there was a whole bunch of stuff that happened before that. As soon as they turned on the videotape, they were like, "Hey, we're Mirandizing you now." So see, it's the start of the video. Then they said that the second factor weighed in appellant's favor. Because there was a very short period of time between the arrest without the warrant, and the statement, the confession. And then the third weighed heavily in the state's favor because his election to speak with the officer was something that he did of his own free will. That's the area where the CCA really tags the Intermediate Court of Appeals. And then the... flagrancy of the official misconduct, the Court of Appeals just kind of gave a cursory overview. We've already decided we're ruling in the state's favor, and we're not going to play around with this whole lot.
Okay.
The CCA says that they get it wrong, which is slide 3 on this case.
So that was all the...
That was all the Intermediate Court of Appeals,
okay.
Yes. This is... The CCA is essentially bench slaps the Court of Appeals and goes, you can't fucking do that.
Yeah.
Good
for them.
Yes.
What Court of Appeals was it?
That was the that would have been the 8th, so that was the El Paso Court of Appeals.
Okay. And they got bench slapped.
Yep.
Okay. And so I'm guessing they said that that those things were not in the state's favor.
Yes. The words that the majority opinion used were that the police misconduct was flagrantly abusive, which when you're dealing with a entirely Republican Court of Criminal Appeals and an allegation of police misconduct, that's about as sharp a rebuke as you could hope to get.
Yeah, it's because probably, I would imagine, and I'm just going to go, I didn't read this, the original transcript or see the interview. I imagine if they're saying that, if Texas CCA is saying that, it was bad. It was
apparent that the conduct was particularly egregious.
Yeah, because it's got to get egregious before anybody starts stepping in. I don't know if you've seen the interview of the guy who was shot in the head twice and they didn't know.
No.
Oh, you gotta look that up. Look it up. I wish I had the name. I have a video about it on my YouTube, but I'm not pitching anything here because this is a CLE. So I'm just saying, look up the guy. He's got 2 bullets in his head, and they're interviewing about the murder of his girlfriend, and they interviewed him for like 45 minutes, and then they held him before the interview for hours. And then finally they go, hey, I think this guy might have a bullet. He's been shot in the face that I've been looking at for the past 45 minutes. And they get a medical help, and then it turns out that he wasn't the bad guy. They shouldn't be interviewing him. And again, that was like, nobody got in trouble for that. It was like, that's not good. We'll try next time not to do that. It's once in a lifetime thing, right? That you're interviewing someone who's shot in the head. So anyway. It's got to be bad for the CCA to go, that's bad.
Yeah, when the CCA calls it flagrantly abusive, it's like, wow, guys, you
because they got cases where the guy was like handcuffed without food and water for like 7 hours, and they don't even blink an eye.
I mean, this is the same court where a member has publicly and without briefing argued in favor of the execution of a mentally incompetent guy because it's convenient, and that's better for him. And they're like,
this is great.
And they called this flagrantly abusive. So imagine how bad it had to be.
Yeah. All right, well, good for them. At least they found it right. Now we got Matthew Allen.
Yes, Mr. Allen was convicted. This is another one that got convicted of multiple sex offenses. They violate double jeopardy because they're lessers of the greater offense.
So maybe are they doing this just continuous is 25 to life, right?
Yes, no parole.
Are they just afraid of missing the continuous, so they just stack them up, or what?
The theory that most of the DA's offices will use when they are indicting both for a continuous and for lessers, either ag sex or indecency, is that when they are specific in their dates on the continuous, that they are still allowed to proceed on the lessers and then stack those also.
Okay.
Since they don't have to prove dates for the continuous, even if they allege specific dates, that's dumb.
Are they doing this in hopes of getting a lesser included if they don't get a big, and then
this is one of those ones where they're going to stack as many charges as possible so they can argue, look at what an asshole this guy is. You have to convict him of at least one.
Okay, gotcha. Yeah. But then but I'm saying they're not purposely trying to get these, or are they? Like, are they cool with it when they find all three?
Oh yeah, absolutely.
Oh, okay. Well, then never mind. I was trying to give them credit.
And then we file the double jeopardy argument, and the Court of Appeals goes vacate the lesser. And this is the one that finally conclusively decided the question of if you get convicted of a greater and a lesser sex offense that violate double jeopardy, which one gets vacated and which one gets stays.
And which one gets vacated?
The lesser offense gets vacated, and
so
the greater
you get
offense stays.
the upper offense. So, but essentially,
they're never going to make the DA's job harder.
Correct, but correct me if I'm wrong. So why there's no punishment, like a punishment for the DA?
Oh, no.
You could just keep doing this.
Yes.
Because if you get it, they're just going to vacate the lowers, and you get the uppers. Great. Good job. So essentially, they can keep doing this. That's what this says.
Yes.
Okay. All right, cool. They're just going to vacate the lower. All right.
Yep.
All right, Robert Harrell.
Robert Harrell is one of the first few on death of the corpus delicti rule. This is one where it's a DWI case where the only evidence that the defendant himself is driving is his statement that he was driving. There's a 911 caller during the court says, hey, I think I've got a drunk driver here. By the time they get to the vehicle is stopped. Multiple occupants are outside the vehicle. He says, I was the one that was driving, gets arrested for DWI. The Court of Appeals, following the corpus delicti rule, said that the evidence is insufficient to corroborate the corpus delicti statement.
Because there's no evidence that he was driving. He says, I'm driving, but the caller says this guy was driving.
Yes, and without more, that's not enough.
Okay.
You have to have more than just the admission to the element of the offense under the corpus delicti rule.
I'm guessing the CCA said, nope, confession's enough. Am I right?
Good enough, yep.
How did I know that? Confession's always enough.
Yeah.
Forget that they're wrong all the time.
It was corroborated by all of the things that couldn't identify this guy as the driver.
Yes. All right. Yeah, there you go. So, there's nothing. If there's nothing, corroboration is there's no evidence against him.
Pound one more nail in the coffin that is the the corpus delicti rule.
Hey, don't confess. I just gotta say that. I don't know if you're not telling your clients this. Don't confess. Just don't confess to anything, especially something you didn't do. But don't confess. Like, that's no matter what, just don't confess. Can we say that rule?
It's like Fight Club. The first rule of getting arrested is shut the fuck up.
Yeah.
The second rule of getting arrested is shut the fuck up.
Well, every one of our clients is like, hey, look, I only copped to the weed because I didn't want my girlfriend to get in trouble. And you're like, yeah, that's why we're here. He's like, but that's not fair. I didn't actually have the weed. And you're like, no, I think you just said you copped to the weed so your girlfriend doesn't get in trouble. So here we are. And they're like, that's not fair. I'm like, pretty sure you don't know how that works. So now, again, don't confess.
Yes.
Christopher Miranda, another Miranda.
Christopher Miranda is another corpus delicti rule case. This was an improper relationship between student and educator. High school coach liked fucking some of his athletes. And, of course, there's an outcry made that's followed up by more outcries and more outcries and more outcries. And by the time this thing comes around to trial, they prove up a bunch of their cases, but the only thing that they've got is, for one of the complainants, for PV, was his statement admitting to the principal that he was fucking his athletes, because Rule 1.
Not this specific athlete.
With regard to this particular juvenile, the only evidence that there was his admission to the principal.
But not. He didn't admit to this particular. He admitted to the principal. I boned my athletes, and they brought it up in regards to this particular witness. Am I saying that right, or did he say I am boning Jane?
Yeah, it was. I've been boning Jane and Sarah and.
Oh, he did. Somebody mentioned Jane.
And there was corroborating evidence for everybody except Jane.
Gotcha.
And Again, Court of Appeals reverses corpus delicti rule. CCA says, guys, these MOs match completely. And so even though there's not any evidence that we would actually need to corroborate this, we're going to use how identical these offenses are as enough evidence to not give you corpus delicti rule.
Correct. And so, again, don't confess. But in this one, it does. The legislature has legislated other stuff that says that if it's an MO, it can be used, right?
Yes.
So this is not surprising.
Oh, no, not even a little.
Fifth lock.
This is an immigration issue. They failed to admonish on immigration consequences as required by 2613 in Code of Criminal Procedure. Unfortunately for Vith, he was deportable many times over with felony convictions in at least 3 states. So the CCA said, look, the better practice is to admonish him, but we don't think it was going to make a difference here because he was deportable 3 or 4 times over already.
Gotcha.
And there's no credible evidence that this would have affected his decision to enter this plea.
And this probably, I should ask you, because I don't know, is this going to affect anything in the future except for guys who have tons of back time?
This will be good case law for the ones that are alleged to have been ineffective for not giving an immigration advice where they were already deportable.
Okay.
But that's about it.
Okay. Yeah, so just those ones. We still have problem. You still should advise all of your clients about the fact that they are going to get deported. You should just say it. Just say they are. You're going to get deported. That's what you guys say. Have them sign it. Ex parte Jordan Bartlett Jones.
Oh, this is a fun one. This is the invasive video photography statute.
Oh, yes.
Interestingly, this is a non-precedential memorandum opinion, and this is one where the Intermediate Court of Appeals at Tyler had held this statute to be unconstitutional. The CCA, relying on, of all things, the sexual privacy of the individual, says that no, this is fine. We're going to let this statute be constitutional because sexual privacy all of a sudden.
What was the basis
matters.
of the unconstitutional?
It was a First Amendment issue.
Okay.
And they essentially said that no, because of how narrow this is, people's right to sexual privacy for anything other than abortion actually matters. So no, this statute's fine.
Gotcha.
I don't.
But why the non-presidential memo?
I don't. I think that's the only way they got to a majority opinion.
Oh, gotcha. Okay.
Because this one was out for long enough. You see, this one's almost as old as Watkins was.
Wow.
Actually, I think this one might have been even a little bit older than Watkins by the time it was finally decided. So you're looking at almost 3 years from petition date to dispo date. And usually
basically they were trying to say sexual privacy outweighs First Amendment rights, but we're not going to actually put that in a decision that somebody can use.
Yes, it is. When we start talking about the value of sexual privacy, we can't possibly create a precedential opinion because it could be used for something like abortion or homosexual rights or things that
we don't want to touch. They're icky.
Yes.
They're icky, and so we're going to move on to Michael Hammock.
Yes, Hammock is service of an emergency protection order that removes a child from custody to establish interference with child custody. Service is not necessary. Only knowledge of the protective order is necessary.
Okay, but knowledge is necessary.
Knowledge is necessary. Actual service is not.
Okay, so in other words, you can't interfere unless you know, but the actual service is not required. Just testimony as to he knew. It's going to be sufficient.
Yes.
All right. Spielbauer.
This is a jury selection case where the issue before the court was whether a juror who gave an answer on their questionnaire, on their written questionnaire, was per se disqualified.
Is veneer members one word, or is that just a typo?
That's one word, yes.
Oh my God! All right, I didn't know that. So, write that. Fancy.
Yes.
Sorry, go ahead.
This is whether you get to rehab a juror that, from their written questionnaire answers, would have been subject to an immediate strike.
Yes.
They can be rehabilitated. They are not subject to an immediate strike. They still get to stick around for questioning.
Okay. Was there
This is honestly going to make picking a jury in a capital case much longer and more pain in the ass process.
Because we used to be able to dismiss them and maybe even bust a panel before we get there.
The ones that they would have said in their questionnaire, I absolutely cannot assess the death penalty. Well, congratulations, you can rehab them now.
Yeah. So now we got to pull them up and go, but you could. You can follow the law. You can follow, right? The law says you got to put them to death.
You don't know what the facts of this case are. Yeah. This guy might have chopped up 10 babies.
Yeah, you would. You want it.
Some people just need killing.
Yep. Yep. Exactly. Even the.
So the only real long-term issue here is this is going to make capital jury selection a whole lot longer.
Good luck with that, guys. This is Kedron Pugh.
Yeah, Kedron Pugh. This is not new.
And this is a Miranda. We've had a Miranda, but here's an actual Miranda.
Yeah, this is where the police violate Miranda and then find physical evidence as a result of that violation of Miranda. Only the statements are excluded. The physical evidence can still come in.
How much does the CCA and the Supreme Court love to just write opinions like this where it's like, duh. I don't know.
This is one where there had been some issues in the Intermediate Court of Appeals with whether Contreras, which is the case that generated that rule,
yes,
was still good law, and this is the CCA coming back around and saying, guys, we said it, we fucking meant it.
Yeah. That's so again. Hey, they gotta love that, right? It's not hard. They don't have to rewrite.
Yeah, well, I mean, you also have to keep in mind that there's only Presiding Judge Keller's the last of the members of the court that's still there that was on the bench in 2010.
Yeah. Ex parte Joseph Gomez.
Gomez, this is another one of the ones where the court just decides that they can do whatever they want. This is one where the trial court may sua sponte increase bail. Bail and bond for purposes of Chapter 17 are used interchangeably. And when the magistrate sets bond and then the client gets out and the judge is like, the fuck, why'd you set that so low? They can just call the client into court and be like, your bond's higher. Congratulations. Go back to jail.
Okay, but I'd like to at least... I have a trouble with bail and bond. I'm just going to tell you, I've always wondered the difference, and now there is no difference. So I was smart the whole time. Basically, this is just allowing them to do what they were already doing.
Yes, and essentially the way that they parse Article 17, subsection 9, which is the bail can be revoked if the original bond is defective, excessive, or insufficient in amount, or if the sureties are not acceptable, or for any other good cause.
Yeah.
They essentially said that or for any other good cause is a separate issue. It is not a requirement for any of the others.
Okay.
So you essentially don't need any cause at all to just say that bond's not high enough.
No, you got to have any other good cause. That's what's not clear about that. All right. And so, what is this going to mean for our bonds?
Trial court can do whatever the hell they want.
Yeah, but they're already doing. I don't know about
Yes.
where you practice, but where I practice.
Yes. No. Fair. That's
like-
no. That is
They're
just.
like, do I have to give them a bond? Do I? Where's the no bond statutes? Does this fall in? No. Okay. Well, we're gonna raise it anyways. Hey, do you have an interlock on? Do you have an interlock on your car? Anyways, all right. Jamal Johnson. Wait. Oh no, that's
Yeah. Johnson's an ineffective assistance case where the Court of Appeals finds trial counsel to be ineffective, which is pretty much impossible to do in direct appeal because you don't have the record that establishes the strategic choices. And the CCA comes back and says, "Hey, we don't have enough of a record for you to do this. Go back, try again."
So this is for ineffective assistance,
Mm-hmm.
and you got to have a good enough record.
Yes.
All right.
Which means a motion for new trial with affidavits, preferably a hearing at which counsel testifies as to what strategic choices were made and why they were made.
Gotcha.
Otherwise, you're wasting your time filing an ineffective assistance argument on direct appeal.
Well, you kind of already were. I don't know. I filed one where the attorney signed something saying, "Here's the reasons I was ineffective," and they didn't care.
Yes.
Sorry. Okay. So this just affirms that, right?
Yep.
All right. Cool. You got to do more, and then we still won't care. All right. Tillman.
Yeah, Tillman's a Fourth Amendment case. Expectation of privacy in a hotel room after management kicks you out. Fun story. After management kicks you out, you don't have a reasonable expectation of privacy in the hotel room. So
what do I do with all my drugs?
You flush them.
What? Those are perfectly good drugs. How dare
So
you?
no basis for a motion to suppress where the hotel had taken affirmative steps to evict the people in the hotel room.
Okay, and so yeah, we already knew that, right? This is another
that's
easy
not
one,
new.
right? Okay, cool. Ricardo Mata.
MATA is a public safety exception to Miranda. That is well established. That's been the law for 30 some odd years now. This is one where there was a kidnapping. They arrested appellant. They seized appellant, interrogated him for a while rather aggressively. He made incriminating statements. They went and they found the kidnapping victim safe, and then arrested appellant because he'd given them the statements that led them to finding her. And at trial, they said, guys, you didn't Mirandize him. And they were like, you don't have to. If he knows where somebody that's missing and possibly in an emergency circumstance is, we're not going to wait for you to go and get him a lawyer so that he might not incriminate himself, and that would make it harder for us to prosecute him. That can't be a thing.
That can't be a thing. But that's already been done, right? I mean,
this is another one that's not new.
Not new at all. This is time and time again. If you kidnap somebody, and again, they keep pushing it. This isn't even pushing it as far as what public safety is.
This is well within the existing public safety exception.
Wexler.
Wexler, this is another case where detention is not a detention for purposes of arrest for purposes of Miranda. This is one where the Houston Narcotics Specialty SWAT Division raided a house. They lock up female occupant of the house in the back of a squad car, interrogate her. She gives incriminating statements. They don't immediately arrest her on scene.
They let her go.
They let her go. Subsequently issue an arrest warrant.
That's all you gotta do.
And then the court says, hey, she was very clearly detained by a lot of scary men with guns, but we don't think that's an arrest. So since she wasn't arrested, they don't have to Mirandize her. They get to use the statements because the statements were the linchpin in the state's case against seven other defendants.
Yeah, and so we can't throw that out. And so, was she handcuffed back there? Do you know?
I believe so. I don't recall.
They have to be. If not, they're violating their code of conduct. But
yes.
Anyways, and so I see you got a dissent on there.
Yes, Judge Walker and Judge Newell dissented, basically as to how the court makes the determination that she was not in custody.
Yeah, and they just said that's probably not a good determination?
They would have likened it to a traffic stop as opposed to just going through all the mental gymnastics that the court used to get to she wasn't in custody.
Okay.
So they would have gotten there. They would have gotten to the
same result. They just would have said, no, it's not. She's not in. She's sort of in custody, like when you're a traffic stop. You're detained, but you're not actually detained.
Yeah, same result, different path to get there.
All right. Well, there you go. Those Miranda rights. All right. Ex parte Allen.
Yes, Alan Christopher Langclose. This is the one that the CCA decided on a super expedited basis. This one went less than 2 weeks from granting PDR to decision on the merits. This is a 17-151 case.
So they didn't find for the defense. I'm just going to go out on a limb there.
They did.
They did? I was wrong. I can't be more happy to be wrong.
This is one that bypassed Governor Abbott's Emergency Order 13, which is kind of what everybody thought this was going to be when they granted it on a super expedited
We've been waiting
basis.
for these. So we've been waiting on the GA-13s. That's all we've been waiting on. Come on, man. You can't suspend habeas by a executive order.
So
and they've managed to tiptoe around it, and just when we get to it, here we go again.
Yeah, so what this case says is that 17-151 is mandatory, hard stop, but it only requires reduction. It doesn't require a PR bond. So, like, the judges that have been doing the $1 bonds for the 90-day bonds that can't be PR'd because of GA-13, they're like, guys, green light. Go ahead and keep doing that.
All right. So they're doing, I had a really smart lawyer giving me a $1 habeas bond sort of thing that pretty much said, hey, you can't suspend habeas, but instead of arguing it and waiting for them to expedite it or not, how about you just do $1 bond? And the judges have been jumping at that because nobody wants to find GA-13 unconstitutional because it's unconstitutional. But they don't want to find that because, politics. And so this one does the exact same thing, but it does, but it pretty much says the $1 part is fine.
Yep.
So they just, all right, good job to whoever that smart lawyer who gave me the $1 bond was. All right, and so it doesn't touch GA-13 really.
It does not specifically address GA-13
but it does by saying you can go down to $1 bonds instead of no bond, which is what we're talking about.
Yes.
All right, good for you. I mean, this was an incredible thing that happened, it's incredible. I just got to say, the fact that pretty much every court in Texas worked diligently to make sure that an unconstitutional executive order was not found unconstitutional. It's pretty amazing.
Yes.
It's pretty amazing. I mean, just usually there's one spoiler who's just like, nah, I'm letting it go. And I haven't seen one yet, so I assume there isn't one.
There was one out of Austin that I don't think went up. I think the DA's office opted to dismiss the case instead of running it up.
That's what I mean. I mean, the judges, the DAs, and the defense attorneys just pretty much. And again, the defense attorneys, not to their credit, they're just getting their clients out of jail. So you can't not get your client out of jail.
Zealously advocating for the client that they have, rather than setting better law for all of the other clients that might be out there.
And so, but I'm saying the DAs, the judges, I mean, to not get 100 of these is bananas. It's amazing.
Yes.
But maybe not so amazing in that they just literally let an unconstitutional executive order stand. But it didn't. We pretty much, to be fair, I'm going to give credit to the defense attorneys. With the help of, we kind of forced the prosecutors, which is we just pretty much took the teeth out of GA-13. You would agree with that, right? There was no teeth to GA-13. Essentially nobody who wouldn't be held before GA-13 was being held after GA-13 because everyone's like, shh. It's unconstitutional, but we don't want it to be fined. So I'm just going to make the bond $1. I'm just surprised nobody had someone who couldn't pay the $1. That's all I'm surprised at. All right, Thetford.
This is an appellate procedure issue. Was a attempted murder case where the appellate lawyer should have argued evidentiary sufficiency and didn't. The Court of Appeals, the state in their reply brief essentially says, guys, like, it's interesting that you forgot to argue the thing that says we didn't prove our case because we didn't prove our case. And so it goes up. So the Court of Appeals declines to sua sponte review for evidentiary sufficiency. Conviction gets affirmed. The appellant's PDR goes up. And the CCA says, guys, you can do that when it is obvious from the record that the state didn't prove its case. You can review that as unassigned, meaning unbriefed error. Send it back, guys. Since it was this obvious that they should have briefed sufficiency, send it back for a sufficiency analysis.
So that's good. So that's kind of, you're not going to let you loophole out of this.
Yeah, this is a unicorn. I don't think you'll ever see this fact pattern again.
Why you got shit all over my... Try to give them credit, man. All right. So next, Andrew Anderson.
Timeliness of notice of appeal. This is another appellate procedure issue. Defendant acting pro se mailed the notice of appeal to the wrong address, so the court did not get it within 10 days. Because it was mailed mailed to the wrong address, it wasn't timely. Appeal dismissed for want of jurisdiction. No timely notice of appeal.
Okay, and so that is finding against him.
Yes.
All right. So yeah. So you pro se. I know lots of pro ses are watching this. Make sure you file that appeal on time and to the correct address. Double check it in your local law library. Somebody had a bad jailhouse lawyer. That's what that was. I'm telling you right now. I bet he got the bad address, and if he didn't put that in his appeal, that I got the bad address from my bad courthouse lawyer.
Yeah, well, that's one I have, my memory serves. That was one where he just wrote the courthouse address on there and didn't address it to the district clerk.
Oh.
So it got lost in that kind of interdepartmental mail.
Gotcha. Yeah, that happens. Well, make it to the district clerk. Again, your jailhouse lawyer should help you with this. So make sure you get a good jailhouse lawyer. Or you could just pay somebody. Robert Herron.
Herron is a sufficiency of the evidence, a relatively rare defendant favorable sufficiency of the evidence verdict from the CCA. This was a failure to register as a sex offender case where the indictment alleged specifically that he did not register an address in El Paso County. But since there was no evidence that he ever went to or resided in or intended to reside in El Paso County, you gotta be planning to move to El Paso before you have a duty to register in El Paso. And since they didn't get there, that is long and short. You guys indicted on the wrong theory, and you didn't prove your case.
And the CCA upheld it.
Yep.
Said you can't do that. That's not a unicorn, though. You can't do that.
Yeah, that's sloppy indictment work from the DA's office.
All right, but hey, that's a win. Good job, CCA. See, I knew I'd give him credit somehow. All right, Oscar Minjare Sanchez Jr.
Yeah, this is Sanchez is a post-conviction probation writ case. So writ of habeas corpus under 11.072 as opposed to 11.07.
Okay.
And
what's the difference? Come on. You can't do that.
Long and short, the difference between the 1107 and the 11072 is the 07 they're in custody, the 072 they're on probation.
Okay, probation versus
yes.
in custody.
The 07, okay. Yeah, the 072 is a non-custodial post-conviction writ.
Yes. So you get a whole different set of
procedural rules
because you're not in jail. So
yes,
shut up.
and so you don't have to use the prescribed form. You've got different, so you can kind of draft your own. Yeah, create your own adventure in your drafting. The issue here is on how the fact-finding works. So for an 1107, the Court of Criminal Appeals acts as both the finder of fact and the finder of law. Under an 11072 case, the trial court is the fact finder, and the Court of Appeals decides what the law is.
Yeah, so basically those finding of facts and statement of law is important in those, right?
Yes.
And less important than if they're in prison.
Yes, and for appellate review of an 11072, the trial court's factual findings are entitled to the same level of deference as jury findings or judicial findings on a motion to suppress or any other time the judge acts as fact finder.
Okay. And so is this changing anything or just
no.
Clarifying?
Yeah, this is a clarification.
Okay, that's what I thought, because I thought we'd already that was pretty clear that they're supposed to find a fact. But this is essentially just saying, no, for real, we're going to give deference to them.
This clarifies the difference between the fact-finding procedure for the 11072 versus the 1107.
All right. Kendall Bell.
Bell is recognizing that Bell cites back to Thompson, which was the first case that we discussed, on the abrogation of Moon. While Bell was pending, Moon was abrogated, so they sent it back to the Court of Appeals, and they're like, guys, we changed the rules on you, go back and try again.
Yeah, so this is literally the Moon case that they just gutted and said, we're done, we're turning away from it. Like, they didn't even take any part. They didn't leave Moon at all. They're literally just like, we were wrong. Which is rare. I like to see it. I just like to see it in favor of maybe the citizenry. But this kind of said, okay, look what we did. Now go back and screw this guy. Right?
Yes.
Okay, good. All right.
And that's it.
That's it. All right. Thank you so much, sir.
Of course.
I appreciate you going over this case law. What's your website? Well, we'll put it all in the description below. Thank you, Jason Niehaus. I'm Seth Fuller. We hope you enjoyed this, and have a good one. Oh, can they email you questions?
Yes.
If you have any questions, email Jason at the below, or if you're okay with it being public, comment below, because this is going to be on YouTube at some point, and so just comment below, and I'll get Jason to answer for you or something.
Yep.
He'll keep track of it. All right, thanks guys, and have a good one.